Brown Mogotsi failing to appear before the Madlanga Commission yesterday, citing ill health. He's since submitted a medical certificate to the commission, while Paul O'Sullivan also walking out on MPs before the Ad Hoc Committee last week. Let's try and get you an understanding of what the consequences are for people who are found, for example, to be in contempt of court in these kind of proceedings, or rather to be in contempt before the court even enters the space. Bring in now legal analyst, Advocate Emmanuel Netshipise, who's with us via our video link. Advocate, it's great to have you on the show. Thanks very much indeed for making time to speak to us. And I wonder if we can just perhaps start off with definitions, because I do think sometimes these legal phrases can have us in a bit of a tailspin. What does it mean when somebody is found to be in contempt in the context either of a commission or what we're seeing at the committee in Parliament?
No, thank you very much. In an easy definition, contempt is simply a disobedience of an order of court. For instance, if the court makes an order that you have to be in court at 1 o'clock and you deliberately disobey the order of the court, that is contempt. What we'll be looking at is whether you had any intention not to comply with the order of the court. If you did it willfully, then after having been told that you have to be in court, that is contempt.
Right. And what steps would, for example, the Madlanga Commission need to take in order to prove that A. Brown Mogotsi would be in contempt, if in fact that is the case? Because we now have been told that he did submit some kind of medical certificate yesterday.
Ordinarily, an inquiry will have to be conducted to determine as to whether he willfully disobeyed the order of the commission. If the result of the inquiry is that there was no willful default on his part, then there won't be any contempt. Or to begin with, if the commission is satisfied from the strength of the evidentiary material that he will produce, to which in this case is a medical report, if they are so satisfied, then there won't be an inquiry to determine whether he's in contempt or not. Yeah. But the starting point is the inquiry, if there are doubt as to whether he might have committed contempt or not.
And my understanding is that this call is actually not the commission's to make, right? Ultimately, the commission needs to make an application before the court, and the court, a competent court, we'll hope, will then make a determination ultimately.
That is correct. That is if the commission from the inquiry is of the prima facie view that it appears that he might have committed or make himself guilty of the contempt. Indeed, an application has to be made before court. Then the powers is with the court to make a decision on whether he's guilty of contempt and then proceed with the necessary punishment.
We have seen how this could go. You know, I think a lot of people will still remember the time when the former president took this all the way up to the Constitutional Court, which ultimately made a finding against him in what I think was an incredibly scathing judgment delivered by Sisi Khampepe. But I suppose this is my very roundabout way of asking the question. This could take quite a while before there's some kind of final determination, if in fact the commission does decide to go down that route.
Indeed, but we must be alive to the fact that the court can be also approached on an urgent basis. If it is approached on an urgent basis, that is to seek remedies for a speedy resolutions of matters, then it can be dealt with within a short period of time if they decide to approach it on an urgent basis.
Fair enough. What is the typical sanction? Perhaps you can help us understand the worst possible sanction that could be delivered against somebody found to be in contempt.
The discretion of imposing a sanction is vested with the court. From the case law that we have seen in our country, the court have given sanctions from 3 months to 6 months up to 12 months imprisonment as a maximum sanction.
Now, let's perhaps shift our focus to what we saw unfolding in Parliament, which may, I suppose, be slightly different, or maybe not, where somebody who was at the commission decides, before some kind of investigative body, in this case, the committee, decides to walk out before being dismissed. What are some of the consequences insofar as that is concerned? Because yesterday we listened into the legal opinion that was delivered by the advisors in Parliament, finding that in fact he may be guilty of some kind of offence. This is in the case of Paul O'Sullivan.
No, I hear you. That is correct. If a person is summoned to appear before a parliamentary inquiry or any process of the parliament, you cannot walk out unless if you are excused by the chairperson of the inquiry. If you do so, indeed, that is a contravention of Section 17 of the Privileges and Immunities of Parliament and Provisional Legislatures Act of 2004. And you can be found guilty and be sentenced to an imprisonment of a period not exceeding 12 months. That is if you have been summoned. But it is different in the case of Paul O'Sullivan, because what he is contending is that I went there on my own volition. I was not summoned. Maybe the determining key word in this matter, it will be the summoned part.
Yeah, and do you think he's got a point?
Can you come again?
I was asking you if you think Paul O'Sullivan, in what he contends, has actually made a valid point, the fact that he's actually gone there voluntarily. There isn't a summons before him.
In my view, yes, it is, because if we are reading the basis upon which a person might be found guilty, it is if you are summoned. And in this case, he was not summoned. Perhaps for the parliament to get an proper protection or authority over witnesses, all the witnesses who appears before them must have been summoned. It is for them if they want to invoke these provisions. But in this case, they are not protected because he went there on himself.
Let me add a layer of complexity, if I can, Advocate. I mean, in O'Sullivan's case, he mentioned that, you know, he's got back pains and he can only sit upright for a certain amount of time. If he was to be summoned, but needed to leave because of medical reasons, and the chairperson didn't dismiss him, how could that potentially play out?
If he presents some challenges, like for instance, health challenges, it is the responsibility of the chairperson to accommodate him. Even in a court of law, if a witness has some challenges, it is the responsibility of the court to accommodate a witness in such a manner that he will be able to give evidence freely and voluntarily and without any undue influence maybe caused by pain or whatever. So in this case, the duty will be on the chairperson to give Paul O'Sullivan the necessary facility which will accommodate his disability or his challenges. If that is not provided, it will be a good legal basis upon which he might not want to continue.
Okay, all right. I suppose that last sentence answers my last question, you know, because essentially you can't just be at the discretion or at the whims of the chairperson in the event of there being some kind of medical condition, right? There has to be other recourse.
Indeed, there has to be other recourse. Perhaps he can even make an application that he cannot continue in the manner in which maybe the facility is suited because it is not accommodating to his maybe special needs. Then the chairperson will have to make a determination.